at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. You know, I'm trying to follow this factual basis, and I realize I asked Ms. Renard, R-E-N-A-R-D, for this, and we're in a different case.
Yeah, we are. So, I mean, we've been talking about these 2015 crimes, and we've been talking about, you know, what's been going on in this 22 indictment. So, I mean, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because, I mean, I noticed this morning that this was an Alford plea. And I would have had issues with, when you started reading out the factual basis, I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015 case, we believe that it would be appropriate is an appropriate matter for cross-examination, and dropped him off, and it was only one house.
Well, we all know how party to a crime works. So, I mean, yeah, he said I didn't shoot, but he did admit to being the driver.
And so, to the extent that he said that the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on he made a very blatant, inconsistent statement that YSL is not a gang. And in this factual acknowledgement section.
All right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
No, in the 22 SC 183.
Okay, yeah, no. I mean, all of that is inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, you know, part of the 22 factual acknowledgments. So those factual acknowledgments in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not
apply, and that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one, this is true.
I see what, yes,
okay.
Yes.
All right. If anybody wants to suggest specific language, I'm willing to listen. Otherwise, I'm just going to kind of give it my best shot.
I would like,
Your Honor, may I say one more thing?
Yeah.
Because number one, the court has previously instructed the jury that questions, and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest, and given that he can also be cross-examined as to whether or not he can, he was asserting these things, we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness rather is required.
Okay.
I just respectfully don't think that goes far enough. You know, you have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alfred. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total confrontation clause violation. It's the second time.
All right, and that's Zachary and...
Well, Mr. Zachary, I anticipate may testify.
Right.
I don't know. He hasn't yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying. And then, just for you to know, you were not here, but the predecessor judge permitted, over objection, the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alfred plea and said
Okay.
specifically innocent.
Yeah.
I mean, it was a farce.
Right.
And then the predecessor judge wouldn't even let me examine the witness, and Miss Love said that the witness I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness testifying about Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected him to be talking about.
Right. Okay. But nonetheless, we have that now before the jury.
We would ask that the court tell the jury to strike, disregard, put out of their mind anything about Mr. Garlington.
Fully adopt on behalf of Mr. Nichols, and I know I don't need to under the rule we're operating under, the motion for mistrial. I understand your ruling. I understand you're going to give an instruction, but I ask that as part of that instruction for an admonishment under 17-875, and I think that admonishment is mandatory, where counsel makes statements of prejudicial matters which are not in evidence. And I believe that this applies to this particular instance under these particular circumstances. So I've asked the court to admonish counsel. Yes, in front of the jury, obviously, as part of the instruction.
All right. Give me a second to get signed into Lexis and take a look exactly at what the statute says. I'm sure you do. That would be appropriate for the court to give as an admonishment.
I haven't. We can come up with something.
All right. Well, let's endeavor to do that right now.
The 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183572, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demekion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence. Though the factual basis is not in evidence, the fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that that should go, but that was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Ms. Love. I mean, that's just what it is sometimes to be the prosecutor in a case. It's got to have a tough skin. Suggested language, Mr. Harvey or others?
Need for some smarter colleagues to give me some suggestions, which is everybody in these three tables.
And Your Honor, I'm still reading under the annotations of that particular statute
Yeah,
regarding
but you know,
the review.
we also presented this, by the way, as a guilty plea, not as an offered plea. And we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875, and I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard, and the state should not do that again.
Your Honor, what the annotations say is what the law forbids is the introduction into a case by way of argument of facts, not only not in the record, but that are calculated to prejudice the accused. And
All right, Ms. Love, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it. So, I mean, I can grant a mistrial if you prefer.
oh no. I do not
Okay,
want a
then
mistrial.
maybe stop arguing at this point.
Yes, Your Honor.
Okay. Now, in terms of her having presented it as a guilty plea, an offered plea is still a guilty plea, so I don't find there to be anything wrong with her having references in a guilty plea. But, we already talked about the full factual basis thing, so I won't rehash that. But, okay. But after I explain to them what they're not to consider, I also admonish and rebuke you, Ms. Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr. Harvey wants more. What else? I'll consider it.
You should be banned from asking any more questions ever for the rest of them.
Well, reasonably speaking, though.
That may be going a little bit too far. But that's already been asked for, by the way. And that the court, in giving these instructions, intends to rebuke the state for asking for eliciting that improper testimony.
So, Your Honor, it wasn't improper testimony.
Okay.
It was the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court if the court is going to read, that the court reads only what the court initially said.
You should not have put that factual rendition before the jury as anything.
Let me request that the court consider including in its admonition the following language, if the court deems it to be appropriate. Somewhere in there, the presentation of that evidence that I've described was improper and was not in keeping with the law and the prosecutor's ethical obligations. Accordingly, the state is admonished for their behavior and is instructed to refrain from asking or presenting any improper questions or evidence moving forward.
All right. I'll do a little bit of it, but not all of it. What was that last sentence?
I like the first sentence.
I'm sure you do. Instructed to refrain from what?
Refrain from asking any improper questions or presenting improper evidence.
All right. Well, they're not presenting evidence, so.
And
right.
and should conduct themselves within their ethical obligations
All
and
right.
legality.
Thank you. I'm not going to do that.
All right, got some more.
Got some more? All right. I think this is going to be enough. All right. Let's get the jury out. All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alford plea. It's just named after a case called Alford. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard is, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alford plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation, after his attorney said that, to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So, I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to. He had no requirement to. He had no responsibility to. Okay. So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alford plea, you cannot. So none of that I said was actually true about what you just heard about that 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Ms. Love, to pay careful attention to how you ask questions and what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to those curative instructions? All right.